Welcome back, everybody, to this special edition of Beyond the Box Spotlight. Today, I'm joined with Jack Schroder, Senior Associate with Dentons. So we're a little bit different today. We're bringing in some legal perspectives. So, Jack, thanks for coming on.
My pleasure. Thanks for having me, Mike.
Oh, our pleasure. And this could be more of a timely conversation because I think what everybody's seeing right now is there's a lot of appetite in the market for financings, for M&A. And from a company's perspective or founder's perspective, I thought it'd be really, really helpful to bring you on and sort of talk through like what are those things that companies should be thinking about before those financings occur or before those M&As. And there's so many things that can go wrong from the corporate fi side of things that I would love to sort of get your take, given what you're seeing in the market. But before we do that, I would love for you to just give a quick little background on what you do with Dentons.
Sure, yeah. So as you said, I'm a senior associate. I'm in the securities, capital markets, and corporate group. Typically working with public companies, but also work a lot with tech companies of all stages, from very early stage right up to the point where they're doing some kind of exit or doing their IPO and beyond once they're actually public. So my practice focuses a lot on financings and mergers and acquisitions.
Awesome. So definitely the guy we should be talking to on this. So, well, let's just dive right in. So let's talk through a scenario. So I've got a company here and I'm contemplating doing a financing and I haven't put together my term sheet, or I've just got the first term sheet. What's the first thing that I need to do when I'm thinking about this when it comes to the legal perspective?
For sure. So number one, I think in the context of both a financing or an M&A transaction, you really want to make sure that you're always deal ready, especially as you start growing your company to the point where you think you're beyond your seed capital raise, you're beyond your angel raise. Being deal ready is key. So before you start negotiating any term sheet or LOI, it's for sure crucial to involve legal counsel. A lot of times we see folks go ahead and negotiate those themselves or sign them up before we've had eyes on it. And they're not super complex documents, but the thing about it is that they will inform the rest of the transaction. So if you have weird clauses in there or items that create uncertainty because they're not fully fleshed out in the term sheet or LOI, that's something that can cause a lot of headaches down the road once you start negotiating. So first thing is for sure be deal ready. Second thing is involve counsel early in the process.
So let's talk about those two things for a second then. So, you're a founder, capital is limited. I feel like I don't want to spend money on legal to get deal ready if I don't know it's going to happen, right? So when is the right time to engage with legal, right? I've set up my corporation, but like, when's the right time for you to get to know my business a little bit more? Because I'm assuming I know firsthand, there's lots of nuances with these things. And I think it would be definitely beneficial for you to know at least what I do.
Definitely. My view, of course, from the legal side is it's good to have legal counsel involved all the way. And I understand, obviously, a lot of that can be challenging with limited resources. I think you can find people out there, and I know there are lawyers all across Canada that will help with this, but someone you feel comfortable with, a real business partner that's not going to necessarily bill you for every second that you're on the phone with them asking questions or just bouncing business ideas off the wall. The more that you can find someone like that's you have a good relationship with, that you have a good business relationship with, it will help, because getting their knowledge on side right off the bat will help you determine where it's crucial to allocate your limited resources as an early stage company, or even not an early stage company, with regards to the goals that your company has. So even if you're maybe not fully deal ready, your counsel will know where those gaps are and will know what you need to do to get deal ready in the context of either an M&A or a financing.
I think that's super helpful information. But at the same time, there's a lot of companies out there that are maybe a little apprehensive to go to legal because maybe they're a little bit unsure of what they're bringing to the table. And, maybe you downloaded some templates online for some contractor agreements, or you've done this or that. I guess from your perspective, is that just going to get uncovered anyway? So is it kind of the case where you want to get in with somebody you know and trust, the sooner the better? or because sometimes, you know, you might feel like ashamed of what you've kind of put together, because again, you're trying to be scrappy, you're trying to be resourceful.
Yeah, and I appreciate that for sure. And some of the templates you can find online are great, some of them are trash. So the thing is, it's difficult to wade through when you're not, you know, you're not looking at these every day and you don't know the ins and outs of what you're doing. Um, so it's a challenge to figure it out and walk that fine line. I understand that. At the end of the day, hopefully you have an advisor who can give you advice on, like I said, where you want to allocate those resources. If you go too far down a certain wormhole with bad documents or not papering documents, you're going to find yourself in a situation where that expense is going to catch up to you, and it's going to catch up to you all at once. Once either a potential suitor or venture capital firm or investors start doing their due diligence and looking, you know, behind the curtain at the inner workings of the company. And, you know, maybe that's okay. And you have to make that assessment as well, because maybe, you know, you're thinking in the context of a financing or an exit transaction, you'll be more comfortable putting the money down all at once to fix these types of issues. However, one other caveat, and I know lawyers are always talking about risk, that's going to cost a ton of time as well. And another thing I wanted to focus on is time kills deals. All the time, time kills deals.
So I'm going to go back to that for a second, but just to take that thread further, is, you know, one of the things that is talked about a lot in the tech space is, you know, technical deficit. You know, if only could bring in a few more devs. But, you know, what I'm hearing here is like there's also legal deficit, right, or legal debt, where it's, yeah, you know, you're scrappy, you're putting it all together, but the reality, to your point, is going to come a time where you just have to dig in and, you know, get it shiny and get it deal ready. So, you know, as we sort of thread the narrative towards the time killing deals, I'd love for you to sort of touch on, in your perspective, what it means to be deal ready or being diligence ready. Like, what does that look like from your perspective, from a company's point of view, when I'm going to do another financing or an M&A activity?
Yeah, particularly in the technology space, intellectual property is, of course, one of the big ones. So you want to make sure that you have papered everything regarding your IP development to a point where you're comfortable you own either the intellectual property itself or you have full right to use it, and there's no restrictions on that. And that kind of flows through a lot of your different contracts, whether it's licensing agreements, development agreements with software providers, independent contractor or employment agreements, how the company was founded. Because if the company wasn't incorporated when part of the IP was put together, then who really owns it? Is it the initial founder or is it the company? So you want to make sure that these things are all very clearly set out on paper and there's no ambiguity about it, because that's essentially going to be the value of your business when you're a tech company. And if that's not set out properly, any investor or potential acquirer, when they start looking at it, that's going to be a major red flag for them. And it can cause headaches trying to chase people down, especially if your company's been around for a bit and maybe certain people who helped put together some of the tech aren't with you anymore as an organization, and trying to potentially chase them down and get waivers of their moral rights could be an issue.
Right. So, you know, if you haven't done it already, do it now. If you're just starting, make sure you're on top of this, because to your point, you know, let's say hypothetically, I've got an investor coming on and they want to invest and they start looking at the minute book. And in the minute book, it now shows that only a portion of the IP is in there. Now that, in your experience, you know, does that just draw out the deal and, you know, sometimes they leave, or, you know, again, with time killing deals, those investors want to put that capital at work. And if you're not ready, you know, that definitely isn't where you want to be, especially when you work so hard to get that investment opportunity.
And that's exactly right. And it may not tank every deal, right? Some people really like the management team, really like the idea behind the company, and are willing to put the resources behind getting the deal ready. But it definitely has the risk to tank it, has the risk to decrease value, or force you to take more of a discount on equity than you were anticipating taking. And of course, just the expense of fixing these issues when there's someone else looking at it, and then they have to review everything you do rather than just one set of eyes on it.
Right.
And you may be paying for their counsel as well.
Don't want to do that.
Yeah.
So okay, so you deal with tons of different companies from really early stage, obviously very late stage. For those that are more in the early stage, can you sort of talk through what an example of a good deal ready diligence room would look like? Because when I think, data room, due diligence room, obviously there's some great platforms out there that help you, but there's also, Excel and Google Drive. And, just from your perspective, like what paints the picture of like, hey, we know what we're up to, we've got it all in the right space, and this, we feel comfortable going deal ready. Like, what does that look like?
Certainly. So corporate records are, of course, just the very first thing. They should be fairly easy to keep in order, but there's a lot of deficiencies, and I know it's a pain to keep your resolutions and minutes and everything like that together. But if you can keep that one done, that's just going to set the basis for their review of everything else. It's kind of your first impression on diligence. So making sure you have your share cap table or securities cap table well presented and well prepared, as well as all of your director and shareholder minutes and corporate records in your minute book. That's step one. In terms of data room setup, yeah, we're seeing a lot of people move a little bit more to the online minute book, online record keeping. And I don't think there used to be a bit of a stigma around using Dropbox or something like that. But I think that's kind of, people are getting way more comfortable with that, and that's becoming less of an issue. So if you have an online minute book and you're keeping it in one of those, no problem. Beyond that, you have your full suite of contracts. So that's going to be things I alluded to earlier, like your independent contractor or employment agreements, and understanding the relationship with your key service providers. Any licensing agreements should be set out very, very clearly. Key customer and supplier contracts, you're going to want to have those papered. Sometimes you can go off a standard form if you have a really replicable business format, and that's totally fine. And even sometimes, you just have sort of a terms of use or terms of service with a sign on for anyone else who comes to use the program. And then you only have an individual document with your key customers and suppliers. Depending how long your company has been around, it may be that the counterparty just diligences high grade items, so they might not look at everything, but making sure that you have a materiality threshold and you make sure that everything beyond that is well set up. That's what looking deal ready is.
Love it. Well, and I mean, the last thing you want to do is be lying awake in bed at night at 2 a.m. and thinking, oh no, do we have this or do we have that? So, in saying that, I'd be really curious, and I'll give you an example, but I'd be really curious if there's certain things that, maybe most companies aren't thinking of that actually do become substantial when, going to do a financing or an M&A. Because obviously you've got your contracts, you've got your IP. One of the things that comes to mind for me is like releases from contracts, right? Contracts, let's say an independent contractor term, it terminates, it has a termination date. If you want to go above and beyond, there's, get a release where it's saying, it's done and done. What is there anything else that founders should be thinking about that maybe aren't part of that normal, contract stack as they're really looking to put that shine on the minute book?
Well, so part of this is it's hard to say without knowing the specific company. Lots of different issues can arise with any given company, and part of this goes back to not involving counsel in some of that key contract drafting at the beginning. A lot of these things arise when you're looking at maybe a lease that someone entered for their property without consulting counsel. And I've seen some crazy things in leases, like change of control provisions, where you actually have to offer your landlord the right to buy your company before you can sell it to anyone else. That just gets snuck in there sometimes. Or consents for sure are a big one. Any financing or change of control consent. If you have a bank lender, sometimes you'll need consent from them to issue any securities of the company, or else you're technically in default of your lending provisions. So having a good grasp on what your contracts say is really just the key, rather than any particular thing that might be an overarching theme. Um, knowing the big ones in and out is pretty important.
Awesome. Okay, well, just want to round this out here with I guess two closing questions. So if I'm a tech founder, I've got an MVP in market, I'm starting to generate or just about to start generating revenue. Ideally, I should have talked to you, but what's the best channel to approach, say, a company like Dentons? Because from an outsider's perspective, it's this massive corporation. Like, how is the best channel for this young startup companies to go in there if they don't have a relationship already? Is there channels that exist for Dentons, or?
Definitely, we have something called our venture technology group. You can find it online, and we try our best to make this visible to people in the community, but we definitely have groups we understand the challenges of starting a new company or operating a company with limited resources. And I think almost anyone who works with technology groups in our organization is going to be happy to sit down with you, first of all, and do a free consultation, and start building that relationship. And if it looks like the right time or the right file, we're also happy to be flexible in a lot of different ways. I know it's intimidating, and this probably goes for really approaching any big law firm, but reach out to a couple, I would say, and just get a sense for who you're talking to. And eventually you're going to find someone that you click with that gives you the right sense that they're going to understand your business and work with you kind of in a partnership way, rather than someone who's just a service provider.
Love it. No, I think it's great advice. I've seeing it from both sides. I can't help but reiterate exactly what you're saying there. And it's so nice to have somebody that you can trust as part of your team, right, going forward. And so there's been a ton of great content on here. So the last question, Jack, is, so if I'm a founder and I'm listening to this right now, what is the one thing I need to make sure I'm on top of, in the next 24 hours? You've obviously, let's just to drill home that point, what's the one thing I should look into to make sure that I'm feeling pretty good about that as I go forward to grow my company?
In the context of a financing, I would say make sure you have a handle on your cap table and any investor rights that you have. If you have a unanimous shareholders agreement, or if you have any investor rights agreements, make sure you're very, very comfortable with what those rights are and what that cap table looks like. And you're not going to accidentally go offside any provisions in those documents. For anyone who's anticipating an M&A transaction, back to what I was saying earlier, just start making sure that you understand your key contracts right now. And if there's any ambiguity or anything that you think needs to be sorted out, I would get ready in advance of negotiating the term sheet.
This has been awesome. You're a wealth of knowledge, good sir. I can't tell you enough how much we appreciate you coming on the show here and sharing some wisdom. For people that would want to learn a little bit more and maybe they like what you had to say, how do they get in touch with you, Jack? Is LinkedIn maybe the best way?
Yeah, LinkedIn for sure. You can also Google my name, and you'll find my bio on Dentons, and feel free to shoot me an email or call.
You are a gem to the ecosystem. Well, thank you so much for coming on. Every time that we chat, I always learn a little bit as well. And that's saying something, consider we've been chatting for quite some time now. But yeah, appreciate you coming on, Jack. And thanks again for coming on the show.
Yeah, it was great. Thanks again for having me, Mike.
Take care.